Good morning, everyone. We're scheduled to start at 10 o'clock. We're just going to give it a few more minutes for some other people to join who might be clicking the link a little bit late. At the same time, I want to be mindful of your time and start promptly. So I'll give it till about 10:03, and then we'll get started. Grab a cup of coffee or water if you like, and then we'll start. Just one more minute, and then we'll get going. All right, let's do it. So good morning, everybody. Welcome to this morning's presentation on campground laws, a preseason review. This is a presentation that I've been doing for the New Hampshire Campground Owners Association, I think for about 2 years now. We did one last spring, we did one in the fall, and then we're doing it again this spring. And it's a great presentation. We're slotted for about an hour of time. It's never taken that long. It about runs a half hour, but there may be some questions at the end. If you do have any questions, just put them into the Q&A box or the chat box. I can't really see them right now the way my screens work, but at the end of the presentation, I'll go through it, I'll read the questions, and I'll provide an answer as I can. If I don't know the answer, I'll let you know. I'm not going to make anything up for you, and I'll try and find it for you if you email me offline, and I'll put my contact information at the end. So today's agenda, we're going to be talking about RSA 216I, which is the seminal statute in New Hampshire governing campgrounds and recreational campgrounds. You should be familiar with it. If you haven't had a chance to look it up, you can find it easily at the General Court's website on Google. It's not a very long statute. Most of the provisions in it don't actually pertain to daily operations of the campground, but it's something that every campground owner should at least be facile with. And we'll go through the higher level points of it today. A little bit of a disclaimer here. While I am an attorney, I work at Sheehan, Finney, Bass and Green in Portsmouth, New Hampshire. This program is intended for educational purposes only and is not a substitute for legal guidance. If you don't work with an attorney who knows this stuff, you should, because there can be a few traps for the unwary. More of an introduction about me is I am principally a labor and employment and land use attorney, although I represent probably a dozen campgrounds or so around the state of New Hampshire. And so around this time of year, my docket gets and my desk gets a little busy with campground work. And I love campgrounds. I grew up going to a campground in Lovell, Maine, the Keezer Lake campground before it shut down. My parents were seasonals, and I spent most of my summer running around, engaging in lots of mischief. I used to have a little folding chair where I would go and like watch people try and like back their RV units and their fifth wheels like into a very tight spot, and they couldn't do it. And when you're being heckled by a 7-year-old, it's even better. So I have a fondness in my heart for campgrounds, and that's really why I do this presentation for the association. So let's get to it. We're going to be talking about RSA 216I, evictions, what the eviction process is under RSA 16I, 216I. We're going to be talking about how you deal with abandoned property. Every campground has that issue. We're going to be talking about the types of agreements that you should be having with your seasonals or other transient guests. We're going to be talking about tax issues, and we're talking about municipal compliance, which I think is one of the most significantly overlooked part of this body of law, so to speak, is what does the municipality that the campground is in require in terms of land use restrictions, site plan restrictions, noise ordinances, whatever it is, as a campground occupying that space, that's an important part of compliance for any campground. So let's get to it. So RSA 216I, as I said, governs campgrounds throughout the state of New Hampshire. It does not govern manufactured housing. In fact, there's a provision in it, I think it's provision 11 or 10, that says that manufactured housing is governed by an entirely separate statute. And this statute defines what a campground is, and it defines what a campground isn't. It is your Bible as operating a recreational campground in New Hampshire. And it defines a recreational campground or camping park as a parcel of land containing two or more campgrounds. The intended purpose of which is for transient occupancy for recreational purposes and not for permanent year-round residency. And I bolded that section on purpose because the way the statute is set up, you can quite easily evict people that you don't want on your campground anymore or non-renew them. But if the person is using the campground and using their RV unit or cabin or whatever it is on the campground for a year-round residency purpose, well, it does a few things. One is it takes the campground out of the confines of this statute and out of the auspices of this statute and puts it in a different statute where the campground may actually be considered a landlord under RSA 540. And as a landlord with tenants, the landlord has certain habitable obligations and the tenant has certain rights, including a far more cumbersome eviction process where you actually have to go to the court, the landlord-tenant court in the circuit where the campground is located to evict somebody. So it's very important that you're operating your campground and ensuring that no one is using the campground for permanent year-round residency because it's going to have complications that really are unintended and is going to make any eviction process more cumbersome and time consuming than it should otherwise be. So, what are the types of things that a campground may host? Tents, recreational vehicles, camping cabins, those are all fine as long as they're not used for any type of year-round residency for any inhabitant. The statute does have density requirements. I'm not really sure actually who enforces these density requirements. I've looked it up. My guess is probably the towns may have similar density requirements, but in any event, I'm going to go over them because it is in the statute. It's possible the New Hampshire Attorney General's office would have enforcement jurisdiction, but I haven't seen any agency with jurisdiction to enforce these provisions. But the density requirements in the statute are a tent site has to have at least 600 square feet per tent site, and any site hosting an RV unit or a cabin has to have at least 1,000 square feet per site. So if you're building new sites, if you're checking new sites, if you're changing things around your site plan, make sure you're meeting those density requirements. If you're not meeting those density requirements right now, I wouldn't get too much heartburn about it because, again, I don't think anyone's really enforcing those things rigorously. A campground at a minimum has to have access to potable water. If it's a private water supply, i.e. a well, that has to be approved by the New Hampshire Department of Environmental Services. So if you do have a private well that's supplying water to the campground, make sure you get those permits with NHDES. Every campground is also required to have sewage disposal of multiple varieties. So every campground, first, as a general matter, has to have a flush, chemical, or incinerating toilet on the property for general use. That's number one. Second, if the campground hosts RV units, which many do, particularly seasonal campgrounds, then the campground either has to have individual sewage hookups that would be allocated to a specific site, or the campground has to have a general sanitation and sewage disposal system. Those systems, including the individual hookups, must be approved by NHDES. Most towns require that. The slight hiccup here, because frankly, no one besides us is really paying attention to RSA 216I, is that sometimes NHDES doesn't really know it has jurisdiction over that issue, but it is what is required under RSA 216I. So if you don't have your approvals for potable water or sewage disposal from NHDES, make sure you get them. Towns may ask about them as part of any type of inspection, and you should keep those approvals on file. Third, campgrounds, according to the statute, are required to register every guest and every camper that comes onto the property. The reason you have to do that is because it becomes important for the eviction process, but also it's what's required by statute. So the registration process is pretty simple. I mean, you don't need to know really too much about the person. You just need to know the name of the camper and their departure date. If it's a guest, you need to know the name of the guest, who the guest is staying with, and the guest's anticipated departure date. And you want to keep that on file. That's it. And finally, fire pits are heavily regulated in New Hampshire. If you get in trouble with fire pits, likely it's going to be the fire marshal who comes to enforce the local fire code. They're not going to be talking to you about RSA 216I in all likelihood. But in any event, if you have fire pits, there's a number of requirements that you have to have for those pits. One is first they have to be permitted by the town and then comply with local fire code. But per the state requirements, they have to meet certain dimensional requirements. They can't have anything 8 feet overhead and you have to have 6 inches of sand and gravel underneath. So if you have fire pits, if you're redoing fire pits, building new ones, make sure that when they're constructed in compliance with RSA 216I. And if your fire pits have not been inspected by the local municipality, i.e. the fire marshal, make sure you do that and get everything permitted before the season starts. Right now, it's April 30th. Many campgrounds are probably at the beginning of their season. My guess is many started around April 1st, April 15th. But we're not at the point yet where, there's a host of campers on the property regularly, school's not out. So this is a good time to get all the permits in compliance before the season really gets in full swing. And you have to deal with things like evictions. Now, there are two statutory options for evictions under RSA 216I. Option one is a sufferance or overstaying. Sufferance is really just a fancy legal word for a tenant who overstays their rights. And option two is a for cause eviction. Now, depending on the situation in which you're evicting a camper, you're going to have to do one of two things to comply with RSA 216I. We're going to talk about, however, that in your camping agreements, you're going to want to build in additional protections for how you can evict tenants who may violate the rules and regulations of the campground. But for starters, let's talk about the statutory eviction processes. So the first one is reasons for eviction under the statutory option one, which is, someone who's overstaying. So any person remaining in the recreational campground in violation of this chapter. Now, remaining includes someone who was previously evicted for cause or under an agreement who hasn't left yet, or a camper remaining past their departure time, or a guest remaining past their departure time. That's why you have to take in the registrations for every camper and every guest who comes onto the property. And including in those registrations, you need their name and their expected departure date. Because then when they overstay, you can simply notify the camper or the guest that the campground, the establishment, no longer desires to entertain them and request they leave immediately. If they don't leave immediately, then you can call the sheriff's office or the local law enforcement office, tell them that they're trespassing, and they will be escorted off the property. That's it. And it's beneficial when you call the sheriff office or the local law enforcement office to say, here's the registration information. They said they're going to be out on May 30th at 9 a.m. They haven't left. They're continuing to stay. We no longer desire them. Please remove them from the property. It's done. It's easy. So that's option one for statutory evictions. Option two is the for cause eviction. And the reasons for a for cause eviction under the statute are the camper or the guest actually is in violation of quiet enjoyment. We're going to talk about that. Or the camper is in violation of a law. That could be a local law, a state law, federal law, whatever it is. There are thousands upon thousands upon thousands of laws. Any one of them will do. So quiet enjoyment. The easiest way to think of quiet enjoyment is essentially disorderly conduct. Although campgrounds really don't operate in this landlord-tenant space, I'm going to use it as an example. Every tenant in an apartment building, let's say, has a right to quiet enjoyment of the property. That means not being disturbed by the landlord and not being disturbed by other tenants, right? Campers camping at a campground have, I wouldn't call it a right per se, because there actually isn't a statutory right written into RSA 216I, but they can have quiet enjoyment of the property. That's what they're paying for, to be undisturbed by other campers, and generally speaking, to be undisturbed by the campground within reason. Any camper who is violating the quiet enjoyment of another camper through boisterous conduct, noise violations, fireworks, whatever it is, uh, can be removed for cause. Similarly, any camper who is in violation of a law, any law, can be removed for cause. Now, the laws, it's broad. It could be a violation of an ordinance. It could be a violation of the building code. It could be drug use. It could be misdemeanors. It could be operating fireworks illegally, moving a fire pit, building a fire that is in violation of the fire code. Whatever it is, if it's a violation of the law, it is grounds for a for cause eviction. Before you evict the camper, however, you have to first attempt to verbally warn the offender that any continued violation, either of the law or the violation of the quiet enjoyment of other campers, will result in their eviction if the transgression continues. You have to give that warning first. Now, a little bit of a caveat here, right? And I think you need to use your best judgment. If someone is building a fire too high or playing their music too loud or violating a noise ordinance, right? Give them a warning. I would prefer a written warning, but it can be verbal. Give them a warning and let them know that, okay, if continued violation, they're going to be evicted. If somebody assaults and batters another camper, right? I don't think you're required to give them a verbal warning to say that, well, if you continue to do this, we're going to evict you. Now, I'm of the position that you can just evict that person immediately. The statute technically says different, but I really don't think anyone's going to challenge that in court. Particularly if you follow my advice in the later parts of this presentation and build in additional grounds for eviction based on your camper agreements. Again, who evicts under the statute or under this version of a for-cause eviction option? It can be the camper, it can be a campground, it can be an agent, it can be the sheriff's office, it can be a law enforcement officer of the state, law enforcement officer of the town, doesn't matter. You call them up, you let them know about the situation, and then the police will come and escort the person off the property. You do want to be a little careful. I'm going to back up 1 second. You don't want to be a little careful there that you're not evicting someone who is inebriated, at least initially, right? If someone is so drunk that they can't drive or they can't think clearly, you don't want to evict them while they're in that state. One, they may become combative, okay, number one. But two, you don't want to say, get your stuff and get out while they're inebriated. Wait until the next morning until the person has hopefully sobered up, then evict them. Because if they do get into a car accident, you could have liability brought against the campground because you kicked them out of the campground. Lawfully kicked them out, albeit, but you just don't want to deal with it. If it's a situation where you need them out immediately because they assaulted another guest and they're inebriated, call the sheriff's office. They'll likely be arrested and they can spend the rest of the night in the drunk tank. All right. There is another little caveat with the option 2 for cause eviction, and this is the one that I think gets campground owners riled up all the time, and it's the complaint I hear about the most. It is that a person who is evicted for cause has 30 days to request a refund of the unused portion of his or her prepaid campsite rental fee or visitor fee. Okay. So what that means is if you evict somebody for hitting another guest, punching another guest, getting into a fight, serious grounds, and they come back within 30 days of the eviction and they say, I want the rest of my seasonal camping fee back, the unused portion of it, you are required by law to give it to them. And this is the complaint I get from every campground owner all the time because it's saying, well, you're telling me that, someone assaults somebody, is disorderly, they disturb my other guests, I'm losing business because of them. And now you're telling me that I have to give them back sort of this fee that they paid that I considered non-refundable. Well, sorry, that's the way the law is written. And yes, you do have to give it back if they make the request within 30 days. If they don't make the request within 30 days, then it's fine. You get to keep the fee. If they, the other thing is you're not required to notify them that they can make the request. You can simply evict them. If they want to read this statute and figure it out for themselves, good for them. Most people won't read the statute. They may just ask for it anyway. Uh, the other thing to know about this is when a camper makes a request for the unused portion of their visitor fee, you are allowed to withhold any damages that they caused, right? So if you charge a seasonal fee of, let's say, $5,000, there's $4,000 remaining of it by the time the camper gets evicted or the guest gets evicted. And on their way out, they drive through the gate for the campground. You have to replace the gate for $2,000. You are allowed to withhold that $2,000 for the replacement of the gate, meaning that the camper who's evicted, if you're following the math here at 10 in the morning, only gets $2,000 back. What I would do in that situation is I would actually provide the camper with an itemized bill for how much it cost you to fix the gate in this situation so that they know where that $2,000 went and that it wasn't simply being unlawfully pocketed by the campground. So that's the statutory eviction processes. Again, there's two. There's someone who's overstaying, and there's someone who's evicted for cause. But for cause is limited. It's only someone who's violating quiet enjoyment or someone who's violating the law. So you either have to find a law that they've violated, or say that the person is ruining the quiet enjoyment of other campers. But here's what it doesn't include. It doesn't include failure to pay, although maybe that's considered a trespass. It doesn't include violations of the rules and regulations of the campground. It doesn't include just impolite behavior and offensive remarks, maybe to staff, because that's not a violation of the quiet enjoyment of other campers. It doesn't include general buffoonery or negligence, and doesn't include, let's say, violations of the campground site plan, although arguably that might fall into a violation of the law. So how do you deal with that situation where RSA 216I falls short? And the way I would recommend dealing with them is having an agreement for every guest, every transient camper, and every seasonal camper who comes on to the property, and says that while there are statutory grounds for eviction, here are the additional grounds for eviction that we're going to spell out to you and that we're going to give you notice of. And then if you violate these things, or if you run afoul of these things, we will evict you. And we're not going to give you a warning. We're just going to call the sheriff's office and say that you're trespassing. And the reason you're allowed to do that under RSA 216I notwithstanding is because what a campground is giving to any guest or any camper is not an interest in real estate. They don't have fee ownership. They're not a tenant. The only thing you're giving is a revocable license that this person can stay on the property that you own for a defined period of time in exchange for consideration, money. And that right is contractual. It's revocable. And so the campground is free to revoke it at any time per the terms of its agreement. Okay. So what I would do is build all of these things into an agreement such that if someone fails to pay, if there's a violation of the rules and regulations that you find intolerable, you can then evict the person and you don't have to go through the RSA 216I process. And granted, it's not a cumbersome process. It's not an eviction process for a tenant, but then you don't have to deal with questions of a written or verbal warning. You can simply evict them and you have broader grounds for eviction. So what do you do with abandoned property? This, I think, is the bane of most campgrounds, and most campgrounds that I represent is how do you legally dispose of property that is left behind? And this happens a lot. Generally, what I found happens is, specifically in seasonal campground situations, is you have an RV unit, right, that's initially brought onto the property, and it doesn't move for years. And then eventually it's sold to another person who becomes a seasonal camper. And as you go down the line and the RV unit is sold and then sold and then sold and then sold again, the RV unit depreciates. And eventually it depreciates to a point where the RV unit may be less valuable than the seasonal fee that the camper is paying, such that when the camper who has it currently leaves, oftentimes they may not remove the RV unit, they'll just abandon it. because why bother paying the expense to make it roadworthy and remove it if the RV unit actually isn't even worth the seasonal fee for the campground? So it just gets, frankly, abandoned. Now, you could try and go after the camper who left it there, but most of the time that's going to be an expensive lawsuit that you don't want to deal with. So there's two options to deal with that situation or to deal with abandoned property generally. It could be a very good RV unit that's simply left behind after someone's evicted and they don't come and claim it. I've seen that happen too. There's two ways to do it. Uh, One is to go through the unclaimed property statute, RSA 471C. I don't recommend going through that process, and I'll talk about why. It's a convoluted process where essentially the way it works is all abandoned property or all property that's considered abandoned becomes the property of the state of New Hampshire. The campground then acts as a custodian for the property until the state of New Hampshire either gives you license to dispose of it or transfers ownership of the property to you as the campground. And most of the time, that can take 2 to 3 years. The problem with that is while the RV unit is just sitting there, local tax liens can accrue on the property such that once you get clearance from the state of New Hampshire to either do something with the property is encumbered with a tax lien. And then in order to do anything with the property, you have to satisfy the tax lien with the town. Uh, that's why I don't recommend going that way. There is another system that is included in RSA 216I, although it is an imperfect system, but it's the best system that I've found so far. And that is RSA 216I allows the campground to place a storage lien on any property that is abandoned and then sell the property at auction for the amount of the lien. So here's how this works. Someone is evicted or a camper departs and they don't renew and they just leave all of their property at the campground. They leave their RV unit, they leave their grill, they leave their deck, they leave a bunch of other stuff. The only thing they take with them is some personal belongings. The statute allows the campground to move the property off the campsite so that the campsite can be relet to another paying seasonal camper. I'll caution you, though, that while the statute allows you to do this, it's not something I would recommend you do unless you know what you're doing. Because while you're allowed to move the RV unit, let's say, to an offsite storage facility and free up the campsite, the statute doesn't provide any type of immunity to the campground. So if you are moving the RV unit to a storage facility and the wheel falls off, it gets into an accident, something happens, the campground can still be liable in that situation. Even though you're allowed to move it, you get no immunity for negligence or damage to the property. So keep that in mind. Whether or not you move the property off the campsite or not, campground does acquire a lien on all abandoned property for the storage and care of the property. Now, what is that? What I generally recommend is that campgrounds include in the agreements that you're all going to have now, or in their rules and regulations, a notification of what the storage fee is for abandoned property. Call it $100 a week, call it $200 a week, whatever it is. What some campgrounds do is they say, all right, well, our seasonal permit costs $5,000. Let's divide that by how many weeks we're open, and that's the storage fee that we charge per week because this RV unit is going to be occupying a site that we cannot then relet to somebody else. That's one way to do it. But I think the best way to handle it is to at least provide some type of advance notification in the agreements, the rules, the website, whatever it is, so that campers know that if property is abandoned, what the storage fees are going to be. After you have storage fees, you should send an invoice to the camper, the person who left the property, to have those fees paid. Now, I'll caution you, those fees are never going to be paid. If someone abandons an RV unit, the idea that they're going to pay, $4,000 in storage fees is unrealistic. But what can sometimes happen is if you threaten, say, look, we have $4,000 with fees that you have to pay now, unless you come get your property. What I often recommend is if someone's willing to come and just clean out their site and remove everything, waive the storage fees and just have everything gone. Because ultimately what's going to have to happen is you're going to have to move it yourself, which is going to cost you money. Assuming that doesn't happen, and someone doesn't come and cleans out their property. If the fees were made unpaid for 60 days, the campground can then sell the RV unit or any other property at public auction. And to do that, you have to provide a notice pursuant to RSA 444, which means you have to send a certified mailing to the owner, a certified mailing to the lien holder. You have to post notices in 2 public places in the town. If the property exceeds $100, you have to publish the notice in the local newspaper that this property is going to be auctioned. Okay, you should get a description of the property, what type of unit it is, how old it is, if you know, and put all of that in the notice. Uh, the statute does require that you at least attempt to obtain the owner information and the information of any lien holders from the DMV, the Secretary of State, or the town clerk prior to the public auction. This is to ensure that the actual owner of the property gets noticed. What I found historically is that when these RV units are essentially passed down from owner to owner to owner to owner, no one, for most of the time, the people don't actually complete the paperwork you need to complete with the state of New Hampshire to actually transfer ownership. So what can happen is someone thinks they own the property, but they really don't. And the owner is still maybe 4 chains down the line, maybe the original owner of the campground, because no one actually sent the paperwork to the state of New Hampshire. So according to any government record, the original owner is still the owner of the property. That person is entitled to notice that their property is going to be sold. They're probably not going to care because they think it was sold years ago, but they're still entitled to notice. And then you have to hold an auction for this property. Now, you don't have to hire an auctioneer. You can do it yourself. What will likely happen is you will send out your notices 30 days in advance and say, we're going to have an auction of these 5 RV units on, let's say, July 1st, 2024. In all likelihood, no one's going to show up for the auction. Despite you placing notices in the town paper, despite you placing notices on a bulletin board, and despite you placing notices to any lien holders and the owners of the property. What will then happen is the campground is allowed to credit bid on the property for the amount owed to the campground for the storage fees. So if the campground is owed $4,000 in a storage fees, until somebody comes and bids over $4,000, right? The campground can say, well, our debt is $4,000. We are buying it for our debt. And the campground is then entitled to take ownership of the property. You should complete an affidavit of sale and then send that information into the state of New Hampshire to actually get a transfer of ownership to the campground. Once you own the property, you can do with it however you like. Assuming there actually is a sale, or excuse me, assuming actually, someone does show up to actually bid on the property and purchase it, there is a priority of auction proceeds. So the first thing is that the expenses of the sale, including council fees, get paid first. The storage charges get paid second. The lien holders get paid third. And if there's anything left over, that goes to the actual owner of the property. This is my interpretation of the statute. It's not the clearest, and there's possible disagreement about whether lien holders have priority over the campground for its storage liens. But I think you can read it fairly as saying that the campground actually gets paid before any other lien holders, such as if there's a UCC lien on the property because the camper was financed, for example. As I said, most of the time, no one actually appears at the auction, so you don't have to worry about it. What's unsaid in RSA 216I is what to do about tax liens, which do happen. Tax liens have, generally speaking, if they're done correctly, priority over everything else, and it can complicate the process because a camper cannot be sold, or the sale or the auction cannot be complete until the tax lien is satisfied. And this is particularly problematic if the campground is going to credit bid on the property and then take ownership of it. Because what's going to happen in that situation is then the campground, because tax liens go with the real estate and go with the property, once the campground owns the RV unit, then it is subject to the tax lien on the RV unit. So you need to be careful about how to handle that situation when you're dealing with encumbered property. So I get this question a lot. It's why can't we simply dispose of like abandoned property or sell it to a junkyard? right? If someone leaves their RV unit there, it's dilapidated, you don't want it there, it's been sitting there for 3 years, why can't you just get rid of it? And the reason you can't is you don't own it. The campground has no right to it whatsoever. It has storage liens on it, but it doesn't actually own the property. And so you have no title to transfer it to a junkyard. And then if you dispose of it and the actual owner gets wind of it and is angry about that, they can then sue the campground for disposing of their property. What's the likelihood of that happening? Hard to say, but it's potentially a lawsuit you don't want to deal with. So going back to eviction notices, I think, as we get into the summer months here, it's helpful for every campground to have stock eviction notices ready and, able to be sent out. These at a minimum should inform either the guest or the camper that the eviction is effective immediately. Again, keep that inebriation thing in mind as to when it's served. It should inform the person of the reason for the eviction. You're not required to by statute, but it's something I always recommend doing, particularly if you include in your campground agreements that we can evict you for any rule or violation or impolite comments or offensive remarks to staff. You should at least inform them of the reason as to why they're being evicted. And the reason I say that is because I do enough labor and employment law to know that you can technically fire somebody for any reason and not give them a reason. But when you do that, people tend to get in their own heads as to why they're being evicted, why they're being terminated or discharged, and they sometimes think it's a discriminatory or retaliatory reason. Those discrimination laws, because your place is of public accommodation, apply to campgrounds too. So I think it's always better to provide a specific written reason for the eviction. The eviction notice should identify any storage rates for abandoned property and therefore encourage people to come get their property so it's not a situation you have to deal with afterwards. And you should establish the contours of access, right? You're evicting somebody effective immediately, but you want them to come back and get their property so you don't have to go through this cumbersome abandoned property statute process, right? You should tell them, look, you have 2 weeks to come get your property before any storage liens start to accrue. Uh, you can only do it during the week, not on the weekends, and give us 24 hours advance notice before you come back and get your property. That's fine. And you should let them know that if they don't come get their property, storage liens are going to accrue on the property. And if those liens are not satisfied within 60 days, everything will be sold at public auction to the highest bidder. So we've talked a lot about campground agreements this morning. Here are a few things that I think every campground at a minimum should have in their campground agreement, regardless of whether that's for a guest, a transient guest, or a seasonal guest. Rules and regulations should be incorporated into the agreement, right? And it should be grounds for eviction, any violation of the rules and regulations of the campground. The rules and regulations, it can be a separate document, but you at least want to make reference to it in the agreement that the guest, the camper, agrees to abide by the rules and regulations of the campground as reasonably updated by the campground. Payment terms, the duration of the camping season, and a prohibition against off-season occupancy as applicable. I know some campgrounds run all year round. You should check your ordinance before you do that. But at least define what the duration of the camping season is. Prohibition against residential use. That goes back to the first part of this presentation and the first part of RSA 216I, that a campground cannot be for permanent residential use. That is a tenancy, and you do not want to create a tenancy. The camper should have a contractual obligation to maintain adequate insurance as defined by the campground. And you should include things like indemnification. If a campground assaults another camper or gets into an accident, and there's a lawsuit afterwards, that camper should agree to indemnify the campground. There should be waivers of liability. There should be provisions about how you're going to handle sublets or assignments, whether those are allowed, whether those aren't allowed, how abandoned property will be dealt with at the campground, and who is responsible for guests and who's responsible for minor children. Finally, this morning, actually not finally, second to last, we're going to be talking about taxes and the 7D exemption process. Many of you may know, and if you don't know, RV units oscillate between a real estate tax and a motor vehicle registration tax, depending on the type of RV unit. What that means is sometimes an RV unit is taxed as a vehicle, and those taxes are sent to the state of New Hampshire, the Department of Motor Vehicles. But sometimes the RV unit is taxed as real estate, where payments are owed to the local municipality. And here's the difference. RV units exempt, RV units are exempt from the real estate tax when it has a valid motor vehicle registration, it has current plates, and it has a maximum width of 8 feet 6 inches while being transported. So if the RV unit has bump outs and those bump outs close down such that there's a maximum width of 8 feet and 6 inches, it is not taxed as real estate. It is taxed as an RV unit. It has to be located at a campground. So what that means is town cannot tax that unit. It instead goes to the state. Campgrounds, by statute, are not responsible for the payment of any taxes imposed on RV units in the campground. Now, that is a provision in the statute that tends to stick in the craw of most towns, at least in my experience. Because what happens is the town will say that the campground uses a lot of services from the town, whether that's water, fire, um, police services, whatever it is, and the campground only pays a minimum tax to the town, right? Because campers are responsible for their own taxes, and a lot of times campers don't pay their taxes. And so towns can get a little frustrated with campgrounds when the town is providing all of these services but not getting a tax benefit in return. At the same time, the campground is not responsible by statute for any of the taxes imposed on an RV unit. There is one caveat to that, and that is if the campground owns the RV unit, if it's a park model, for example, or if it's a cabin and it's owned by the campground and then rented out to guests by the campground, well, in that situation, the campground is responsible for the taxes, which also makes this auctioning and abandoned property process a little bit more cumbersome because if there is a tax lien on the property that's being auctioned, well, first, you can't consummate the sale while there's a tax lien. But second, if the campground does obtain ownership of the property, then suddenly the campground, which was not previously responsible for the taxes on the RV unit, is now responsible under RSA 72. By April 1st of every year, every campground is required to provide the local municipality, the assessing office, with the name and address of each RV owner who's going to have a seasonal permit on the property, and to identify whether the RV unit in question is exempt from the real estate tax or not. If you haven't done that by April 1st, I encourage you to do it now so that the town doesn't get angry with you. Finally, municipal compliance. This is the one area where I think that most campgrounds sort of just sometimes forget about, and that every municipality has a zoning ordinance, and a campground within the municipality is required to abide by that zoning ordinance. Okay. And some ordinances do restrict what campgrounds can do and what they cannot do. For example, there are towns on the seacoast that say a campground can only operate from April 15th to October 15th. That's it. You can't operate in the wintertime, and you can't operate outside of those restrictions without a variance. There are other, there are other ordinances that actually limit how many campsites you can have on the campground, unless you're grandfathered or unless you get a variance. There are ordinances that extend the density requirements of RSA 216I, such you have to have 1,500 square feet. There are ordinances that regulate density. There are ordinances that regulate what can be an accessory structure, whether you need building permits for accessory structures, what you can require for public services and public access. And a lot of towns have noise restrictions that campgrounds are required to abide by as well. Additionally, every campground likely has a site plan with the town. It's somewhere. And you should be mindful of every site plan, every approval, every permit, and your property boundaries. What often happens, particularly with seasonal campgrounds, is there can be, unlawful expansion, and that can be Unlawful expansion of a non-conforming use. So you have this grandfathered use that just expands and expands and expands until it's now an unlawful expansion. You can have unlawful expansion into setbacks. Sometimes you have a seasonal camper that's been there for 10 years, and every year the campsite just gets a little bigger, a little bigger, a little bigger. That can be an unlawful expansion. And in some situations, you can have expansion across property lines, which creates a different issue. Be mindful of screening requirements that are within your site plan, any shoreline protection considerations, particularly around trees, right? If you're within, I think it's 50 feet of, maybe 25 feet of any body of water, there are many restrictions that govern what you can do and what you cannot do on that property, whether you can have docks or whether you cannot have docks, and particularly around issues of tree cutting. There's other issues that if someone goes onto someone else's property and cuts down a tree, it creates issues of timber trespass. And so every campground should just be mindful of its boundary, be mindful of what its site plan says. If you haven't reviewed it in a number of years, find it, look at it, see where you're in compliance, see where you're not in compliance. Because ultimately, even if the town hasn't talked to you in, let's say, 15 years, if you're not in compliance with your site plan, if you're not in compliance with the zoning ordinance, assuming you're not grandfathered, it could become an issue down the road, and it's better to deal with it now. With that said, that is the conclusion of this morning's presentation. I'm going to check if there's any questions. If you have any questions, put them in the chat box, and I'll see if there are. Hmm. Looks like we got 3. All right, so one person asked, evictions. I have been told for campers we should be using the word ejection rather than eviction because they are not residents. Does it make a difference with law enforcement? Which word we use? I don't think it makes a difference. RSA 269 defines it as an eviction. They're not residents anyway. Calling it an eviction is not going to put you under RSA 540, which is the landlord-tenant statute. It doesn't matter what you call them. Question number 2, eviction request refund. Does they have to be in writing, or if they verbally request, or do they still have a refund? Good question. I don't think the statute specifies whether it has to be in writing or not. I think they just have to make the request for a refund, and so long as they make the request, that is sufficient to trigger the refund. But I'm checking right now. Within 30 days, the refund unused portion. Following eviction, said person. Nope. Following eviction, said person may make a written request to the owners. Okay, so I was incorrect. It does have to be a written request for a refund. A verbal request does not qualify. Question number 3, how or when do you file the lien for abandoned property? So good question about filing the lien. There are a number of situations under New Hampshire law where a service provider is entitled to a lien. Think if someone is building on your house, there's a mechanic's lien that automatically is created. And while the lien is automatically created, the laborer has 120 days to perfect that mechanic's lien. And that means actually filing something in court and then recording that with the registry of deeds so that everyone knows that the person has a lien on the property. There actually is, actual mechanic's liens, or if someone performs work on your car, they have a lien on the car. The way the storage lien works in New Hampshire is that the lien is automatically created, much like a mechanic's lien, but you do not have to file anything in order to perfect the lien for storage fees. Rather, what you do is you tell the person, look, the storage fees are going to be $100 per week, let's say, for every week that the property isn't removed. If that lien remains unpaid for 60 days, then we are going to hold a public auction and get rid of the property, and we're going to be entitled to payment of the lien. You don't actually have to file anything. What you do have to do, though, is at least try to identify who the actual owners of the property are, who any other lien holders of the property are, such as if there's a financing lien for the property, and make sure that those people receive notice of the auction. Once you hold the auction, then you can either do a bill of sale, or not really a bill of sale because you're not really selling it. You're going to do an affidavit of sale to either assign the property to the campground or assign the property to a buyer who can then take ownership of the property by filing appropriate paperwork with the state of New Hampshire. And that's it. Thank you, everyone, for coming to this morning's presentation. I hope you all have a good camping season. If you need to contact me for any reason, I'll put my contact information up on the screen. And so long.